This is going to be an unusual, but hopefully very useful segment of Power Hour. The topic is winning energy legal cases with intellectual persuasion. That's winning energy legal cases with intellectual persuasion. So let me give you a little background on why I'm talking about this, and then who my special guest is, and why I think this is a really important topic for everyone, and then particularly people in the industry, and then even within that, particularly within the industry, people involved in any kind of legal case. So on this podcast and on my other podcast, the Human Flourishing Project, I often share principles of what I call intellectual persuasion. And the idea of intellectual persuasion is that you're trying to persuade somebody intellectually, which means you're not trying to manipulate them. You're just trying to give them a super clear, honest explanation of the truth. And the premise is that if you can really connect with their intellect, with their mind, you can make a lot of progress. Now, this is not something that is widely viewed as a good idea. Many persuasion efforts believe that explaining the truth doesn't help at all, and that you just have to manipulate people emotionally. I believe emotional connection is crucial, but I think it's totally compatible with intellectual persuasion, in the long term is incredibly helped by intellectual persuasion. But usually the premise is, yeah, you can't actually persuade people intellectually. You can't really connect with their minds. You just have to connect with their feelings apart from their minds, and that involves some sort of manipulation. And my view about this is that people who say that, usually they're not very good at explaining things, or often they're not even clear what they think themselves. So sometimes I see people, they're defending an oil company for something, and then I'll hear their own views and they don't even agree with the company that they're defending. I'll say, well, how could you persuade somebody else if you don't even agree with this yourself? And their view is, well, I don't need to agree with it. I just need to manipulate people. Whereas my view is, no, if I really believe something, and I have good, honest reasons for believing it, there must be some way to get that across, at least to a lot of other people, or at least move them substantially in my direction. So on my podcasts, particularly the Human Flourishing Project, and if you look at the first 10 episodes or so, there are several on different aspects of, or different elements of, intellectual persuasion. I've talked about these principles, and I've talked about how they've worked for me, and I've talked about how I've used them in my consulting work, primarily helping different kinds of energy companies message different crucial issues to stakeholders, whether it be investor relations, legal cases, government affairs. And recently I was talking to a longtime friend and ally of mine, Michael Mazzone, and he's a very successful energy lawyer in Houston at the firm Haynes and Boone. And I've known Michael for years, but really in the last year and a half, listening to the Human Flourishing Project, he on his own started applying some of the principles of intellectual persuasion and started having a lot of success. And we started talking about it. And then more recently, he became a client of ours, and we started working on some projects together. And he told me recently, we were just connecting, and he told me that he had actually created a presentation for other lawyers about how some of the principles of intellectual persuasion helped him win some major legal cases. So I thought that this would be cool as an illustration in general of intellectual persuasion, and some examples of some of the principles. And then for those of you who are in energy or certainly in law, this may help even more, but I'm going to try to make it of universal interest, and explain how the principles we discuss can be applied in so many different cases. So Michael Mazzone, welcome to Power Hour.
Well, thanks, Alex. Happy to be on.
Yeah, good to have you. I know you've listened to a lot of these, so it's always great when listeners come on the show.
Yeah, almost all of them.
Almost all of them. Wow. That's I really appreciate when people think that highly of the content to consume that much of it. So what I want to do is I want to pull up on my screen the presentation that you shared with me, and then we'll walk through some of the slides, and I'll give a couple of comments, and then you can share how you've applied this in particular circumstances. And I think that's going to be the value. A lot of the value for people is they'll get to see, oh yeah, this is actually something that is working in a real life way. So overall, you have this presentation and it says arguing your case, and you have these elements. Framework is key. Argue to 100, not to 0. Context bridging, and then give your logic, not your opinion. And people familiar with my work on intellectual persuasion will at least recognize the first 3 of these. And then the 4th, we'll see you have a different name for something that I call the opinion story. So let's start off with framework is key. And I'll just give how I think of this, and then you can share how you think of it and how you've applied it to a particular case. So for me, framework, it's a term I love because framework in the physical realm is a starting structure. And the idea, say, if you have a framework of a building, is that the starting structure of the building determines everything else about the building. So when you're building a building, you really want to make sure to get the framework right. And I think the same is true with any thought process or any conversation or any explanation. There's certain starting points in the discussion that you want to be clear on. And then that's going to determine how everything proceeds. So I often divide frameworks into 3 categories. So you can think of your methods, your assumptions, and your values. So a method might be something like, hey, I believe in looking at the full picture of something, not just the negative picture or the positive picture. So if I'm evaluating different forms of energy, I want to look at the positives and negatives of fossil fuels, the positives and negatives of solar and wind, et cetera, not just the positives of solar and the negatives of coal. And I find that when I frame an explanation with a certain method and I can get the person to be on the same page, then the explanation goes much better. And the same thing is true for if we have an assumption that I can clarify that we agree on, that helps. And then if we have a value, that's really crucial, because ultimately in any conversation or explanation, there has to be a common goal that we're after. And often when I'm talking about energy, from the perspective of the planet, I often talk about, okay, well, is your goal the most natural planet possible? Is that the goal, the planet that's least impacted by humans? Or is your goal the most human-friendly planet possible? Is it the place that's the best to live for humans? Because that's not the same as the most natural planet. The best planet for humans requires a lot of development, a lot of transformation, a lot of impact. In some cases, you want to keep it quote unquote natural, but in general, and in many other cases, you want to dramatically transform. So I've found that when I can get on the same page with people about those things, whether it's the methods, the assumptions, or the values, which includes the ultimate goal, it's very helpful. And so I know you've had quite a bit of success framing. So what's an example of how you've used framing to help, to help win a case and really to help, a jury understand the issues better?
Yeah, so the way I look at the framing issue is sort of controlling the questions in a trial to make sure that the right questions are being articulated and argued. I can give you an example of that from a case that we had. So
I would just one thing on that is,
yeah.
So I think of the questions, I mean, that really relates to the goal, right? Because ultimately there's a question and their goal is to come up with the right answer to the question. And then and then that's going to determine guilt or innocence. Do you think of it that way?
Yeah, so the way I've held it in my mind is controlling the questions to be decided in the trial. Mm-hmm. I don't get complete control over that. My opponent has a say as to what questions he wants to be decided, and the court will have precise legal questions that have to be answered as well. But I think the key to me is to frame the case in such a way that the important issues are being debated, and if it's done right, that will fit within the legal questions. Those legal questions will fit within the framing that I've done. So the example I would give is from a case we represented a large company. Let's call it Company X for this, and they were being sued by an employee of a contractor that the company had hired to come work on a well site for the company. Now, the way the plaintiffs want to frame the case is Company X hired a contractor and told it what to do at its well site. The contractor's employee was injured doing this work. The employee lost a leg below the knee. And by giving these bad instructions, according to the plaintiff's framing, Company X breached its duty of care to the contractor's employee, which resulted in the injury. And in the case, the employee was seeking compensation for his life-changing injury. The way to look at we look at framing according to your principles is to contrast it with the typical defense framing. So typical defense framing would be Company X owed a duty of care, did not owe a duty of care to the contractor's employees, but if it did, it was just a limited duty and it didn't breach that duty. If it did breach that duty, the breach didn't cause the injury. And if the breach did cause the injury, the plaintiff's employee is not entitled for the injury for the amount of money he's seeking. That's a very typical framing. It's very lawyerly, and notice that it wholly accepts the plaintiff's framing of the case. Now,
so the plaintiffs, I take the plaintiff's framing as Company X gave an order that made this guy lose his leg, or lose the bottom half of his leg.
Basically, that's it.
And it seems like they're pretty much conceding that, but then there seem to be all these technicalities.
That's right. And that's the typical way to frame the case from the defense perspective as I laid it out. Now, I used your framing principles and I thought, well, this is not really the way to properly frame the case. And I framed it this way. Company X hired this contractor for its skill and its expertise, including its ability to do dangerous work in a safe way. The contractor and this crew, including the plaintiff, had done this job thousands of times. So really the issue in the case is when a customer like Company X hires a skilled contractor to perform work, is the customer responsible for the safety of the contractor's employees, or instead is the contractor responsible for the safety of its own employees? So when the case is framed this way, it's a really different case. And the result in our case was that Company X paid nothing on the claim. In fact, its legal fees were paid for by the contractor, the plaintiff's employer, and the employee who lost his leg below the knee, who was to a large extent responsible for his injury, was compensated through his own company, his own employer's injury compensation program.
Yeah, that's really interesting. So it's so valuable to just be thinking about, okay, what's the starting structure that is going to shape everything else? And yeah, I can imagine that when you frame it the way that you did, somebody could even think you're using, you're a customer of the contractor, and someone can probably imagine, oh yeah, well, I hire a contracting firm, to work on my house, and then somebody loses a limb with a chainsaw. Like, is that my fault? Well, no, I hired them. Like, they're experts in this and they're experts in safety.
That's exactly right.
There's just so much leverage in thinking about, okay, how is this case being framed by my opponents, and recognize it's never being framed to my advantage. And if you think you're right, then it's not being framed with the truth in mind. And then to think about, okay, what high leverage reframes can I do that the audience will agree with because they're right and they're reasonable. And the more you can do that up front, the more it changes the whole case, versus if you agree with their framework and then you try to just make clever little refutations to different parts of their case, it often doesn't work. And then that brings us to the next one, which is arguing to 100. So the way I think about arguing to 100, you have this x-axis of 100 and negative 100, and really 100 represents the ultimate goal or ideal or highest good, and negative 100 is the lowest evil. And my premise is that in any discussion, there's always some view of what is the good and what is the bad. And so an example I use a lot to explain this is not an energy example, but in the 2016 election, I think President Trump rhetorically very successfully argued to 100, or he reframed the debate to argue to 100. So I think of it as, before he was running, negative 100 was increasing inequality, and then 100 was equality. So the real ideal was equality, and that was the focus. And he really changed it to where 100 was make America great again, so American greatness, and negative 100 was American decline. And then by reframing the goal and the evil, he was then able to argue, okay, my policies are bringing us to the right direction. Whereas, and I don't agree, by the way, with American greatness as the goal, unless you mean by that American freedom. And I think there's a mixture of what people mean by American greatness, and part of it is freedom, but part of it isn't. But I'm just using this to illustrate the power of the reframe versus if you just agree, yeah, I agree, we're trying to reduce inequality. Well, then you're not going to be able to say that much if you're advocating freedom, because there is a definite tension between freedom and inequality. So you often just end up me tooing the people who want more state power, whether it's over healthcare or anything else. So I'm curious, Michael, so how have you been using arguing to 100 and how do you think about it?
Right. So the way I think about it is I don't want to start, or I do want to start an argument at least in a neutral position. I don't want to start in a deep hole. And so I hold that the concept of arguing to 100 in my head, to use a sports analogy, at the start of a trial, I want the scoreboard to read 0-0, not 100 for my opponent or 0 for me. And most of the time I'm representing the defendant. So I get to go second in every trial. That the defendant is the party being sued. So very quickly after a plaintiff's opening statement, it could be 100 for my opponent and 0 for me, even before I open my mouth to make my opening statement. Now, if I start trying to explain away the plaintiff's case, when I'm done, and assuming I'm 100% successful, I'm just back to neutral, as you've explained when you articulated the arguing to 100 idea. Now, note that this means that success is climbing myself out of a hole instead of achieving something on my own. Now, some lawyers recognize this problem. There's an expression among lawyers that if you're explaining, you're losing. But some defense lawyers will accept this because they think just getting back to neutral as a defendant is a win. They think if they've nullified the plaintiff's case, that's a win. But I think that's weak, and I think it's better to prosecute my own case, which means arguing the points that I framed earlier and arguing within my framework. So the principle, arguing to 100, is closely tied to the framing principle. Now, to drive it home, just to use the example of Company X again, arguing to 100 mean that I would marshal all the facts of the case that support the idea that skilled contractors are hired for their skill. They're hired for their knowledge of how to work just to be done. They're hired for their extensive experience in having done the work. They're hired because of this particular crew's skills. They're hired because of the contractor's own safety rules and the contractor's own safety record. And that alliance, because I've thought about arguing to 100, and because I've framed it correctly, I've got all the facts lined up in the right direction, instead of trying to explain away why the plaintiff's case is not right. And this is all as opposed to, we didn't do it, but even if we did do it, it's not as bad as the plaintiff claims, which seems really weak, really lawyerly, and really defensive.
Yeah, so an example that this reminds me of, and this, I didn't talk about the contrast arguing to 100, which you did talk about it, but it's arguing to 0. So that basically, so if you think about the example of shale energy in the US, you can think of it as the way it was framed was negative 100 is more fossil fuel use, and then positive 100 is a totally green economy. And when the shale revolution started occurring in the late 2000s, you had the dominant narrative was shaped really by Josh Fox, who created the Gasland movie. And his essential thing was he would just give a litany of explanations of why shale energy, or as he would call it, fracking, was bad. And so he would talk about, first and foremost, this is just using more fossil fuels. And so that's bad. That brings us toward negative 100. But then he'd say, it's causing contaminated groundwater, and it's causing these unprecedented earthquakes, and it's causing cancer clusters. A lot of what you saw from the industry, so he's arguing them to negative 100. A lot of what you saw from the industry is they're trying to refute each one of these, but there was mostly just trying to refute. So they're saying, oh, well, I'm not going to, here's where you're wrong about groundwater, and here's where you're wrong about earthquakes, and here's where you're wrong about cancer clusters. But the best case scenario there, if you're just playing that kind of defense, is getting to 0. But if the other side is setting the direction, that you never even get to 0. And I think this happens a lot in legal cases where there's so many things thrown at you. But if it's really framed in the opponent's way, then you can just sort of reduce people's confidence in it, but they're still not left with anything clear. Whereas what you're talking about is you're giving a clear, a really clear framing of it, where you're saying, no, this is, here's the situation. This customer hired the contractor, including they hired their safety expertise with the contractor's people. And so this is how it played out. And all the facts support the idea that our client responsibly hired this contractor, who then made a mistake or with its employees, or in any case did something that is not at all within the responsibility of the customer.
Right.
So the next one is context bridging. This is a really fundamental aspect of intellectual persuasion, because it gets to the core of what you're doing in explaining something. And I like this little graphic you have here. I don't know where you got it, but it's pretty cool. So it's, for those who are just listening, you can see there's a building. There are two buildings, and people are standing on the top of the buildings, and it's the beginning of a bridge. And they're like puzzle pieces, that the bridge isn't fully built. So there are two separate people. They're being separated by air, but they have these puzzle pieces that can then build the full bridge. And so the idea of context bridging is that when you're explaining something, what you're doing is you're starting with, you have two contexts in mind. And a context is the sum of what somebody knows and thinks they know. So you could think of, okay, I have context. There's context A, which is where they're beginning, and then context B, which is where I want them to end. And I think of it as, to get them from A to B, there are three essential things you need to do. Sometimes you need to add context. So you need to just give them facts or explanations that they didn't know. And then sometimes you have to subtract. So there's something they believe that's not true. You have to get rid of that. And often you have to do what I call modify. So you need to take something that they believe, which is maybe half true, and you have to help them modify it to see it in a different way. So for example, with the climate issue, I'm often doing modification, because it'll be, yes, I do believe that rising CO2 levels have some impact on climate, but I don't believe that they have a catastrophic impact on climate. And that's the kind of thing where it's being positioned before as, oh, you're either a climate denier or you're a believer, which means you're a climate catastrophist. And I'm trying to modify it and say, no, I can believe that we have an impact on climate without believing that it's catastrophic, and with believing that the impact on climate is worth it, given all the benefits that come with it. And so that's an example of modification. But the broader thing I'm always having in mind is, what is the starting context of my audience? And then where do I want them to be? What's the ending context, the context B? And then what are the steps? What are the essential steps that are necessary? And I want to make sure to use my time very efficiently, so that I'm really giving them the crucial context, versus being off topic, or versus ignoring crucial points of context, without which they can't really get them. I can't really get them where I want them. So how are you thinking about and using context bridging?
Yeah, so before we get to that, I'd like to emphasize the importance of these principles we've talked about. I was representing an energy company in one of the cases featured in one of the Joss Fox films. I think it was Gasland 2. And unfortunately, I hadn't heard your lectures on these points prior to the time I tried that case. We took an adverse verdict in the trial court, but we got it reversed on appeal. But I think I would have done a much better job had I heard these talks before I tried that case, because we didn't frame it correctly, and we were arguing from negative 100 to 0 most of the trial. As I said, we took an adverse verdict, but we got it turned around on appeal. But it would have been easier, I think, for our client had I understood these principles better when we first tried that case, which was in, I want to say, 2011. But on context bridging, as applied to a trial, I think it really means, the simplest explanation is identifying gaps in the juror's knowledge and figuring out how to cross or close those gaps during the trial. So the questions I ask are, what knowledge does a prospective juror think he has that isn't quite right, or two, will interfere with the way he views my case? And what does each juror need to know that he doesn't already know? And two, that if he knew, would help them view my case correctly. In other words, I've summarized it as what knowledge is in jurors' heads that I need to fix because it's wrong, or clarify because it's unclear, or add to because it's just not there. And recognizing the principles of context bridging means that my jury selection process is going to be entirely different. So I'm going to try to answer these questions as the top goal in jury selection about the jurors, as opposed to using the jury selection to what lawyers typically do, which is to start arguing their case early, or just trying to somehow identify who the bad jurors are in the abstract, really without the focus on what knowledge do I need to know, what knowledge do these jurors need to have, what knowledge just needs to be fixed, and what knowledge does need to be clarified. So it's really, really important to recognize context bridging, because then I can make my jury selection process much more useful and productive in the case. So the case against Company X provides a really good example of context bridging. So Company X was a giant, well-known oil company. Every single person that showed up for jury duty knows this company and has heard this company's name. And what most prospective jurors will assume about the company is that since they are such a large oil company, they will know more about how to service a damaged well than the virtually unknown service company who was the employer of this employee who lost his leg below the knee. This is a very, very important fact. If Company X knows more than its contractor about repairing a damaged well, then it's much easier to hold that contractor, Company X, responsible for not giving proper repair instructions. But most jurors will assume coming into the trial is 100% not true. Company X, like most major oil producers, delegate to contractors repair of damaged wells, and they've done this for years. They don't have anywhere near the institutional knowledge or the experience in oil well repair that their contractors have. So our jurors thinking otherwise is an understandable gap in their knowledge that I need to bridge in the case, and recognizing the principle of context bridging allowed me to do that, recognizing what I needed to do during the trial that otherwise wouldn't have done without the idea of context bridging.
Yeah, I mean, this reminds me, I'll speak of this in the very abstract, but in some of the work we've done together, I apologize, we're having a temporary emergency. So just going to wait a second. We have a very, very sensitive smoke alarm in our house. And it's very funny because it's I guess it's trying to be helpful, but if there's any smoke whatsoever, it just starts yelling fire, 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 which is really inaccurate and distressing the first time you hear it. Okay, so let's jump back. So this what you're just discussing now with context bridging reminds me of some discussions we've had in our own ongoing work together, where we're looking at a case. So much of it is looking at, okay, what's the starting point of the audience and where do we need them to be? And one key element of that is what are the different confusions often put forward either by the culture, by their upbringing, or often by the opponents that need to be clarified. And this, well, I didn't work with you on the case you're discussing. This is a perfect example where there's just this starting assumption that, yeah, of course, Company X is going to have all the expertise in terms of the employee safety of anyone who's working directly or indirectly for their company, including the contractor. And if you don't challenge that piece of context is going to just destroy people's thinking throughout the case. And so it's just a very high leverage thing to think at the outset, okay, where are they? Where do I want them to be? What are the key things that need to be added, subtracted, or modified? Now, the last slide that we're going to discuss is you have give your logic, not your opinion. And I like this. I'm curious why you chose this graphic of Zach Galifianakis. I don't know if this is from one of the Hangover movies or something, but the point I know you're referring to, the way I put it, is the opinion story. And the idea of an opinion story is that instead of declaring your opinion about something. You tell the story of how you came to your opinion. And by opinion, I don't just mean some subjective view. I mean a conclusion that you really believe in. So when I'm talking about, say, my belief that the world should use more fossil fuels, not less, if I just say, hey, I'm talking to an Uber driver, hey, the world needs to use a lot more fossil fuels. Here are the 3 reasons why. That can often, like many declarations or statements, breed resistance. But if I tell the story, and I'm sure you've heard me tell the story in different forms, but I tell the story, hey, I was really interested in, I didn't know anything about energy. I learned that this is the industry that powers every other industry. I was really interested in what are the best forms of energy for the future. So I wanted to look at the pros and cons of each. And I was surprised when I concluded that fossil fuels have far more pros than cons. And there are certain things they can do that no other form of energy can. And I actually became very pro fossil fuels. If I tell some version of that story, it goes over much better. And one reason is because it really respects the independence of the listener. I'm not declaring to them what they should believe. I'm not even claiming that I'm right. In a sense, I'm recognizing they don't know they don't know if I'm right or not, but I can tell them the story of the thought process and discovery process I went through. And then if that sounds appealing to them, they can think, oh yeah, I might go through that process myself. So I'm curious, how are you thinking of opinion stories, or as you put it, give your logic, not your opinion, in the context of your legal work?
Right. So in lawyer language, we say you have to show the jury as opposed to telling the jury. Mm-hmm. And so one teacher of lawyers put it this way: you're a lawyer, you're supposed to argue your case, but you don't argue your case. It's kind of a paradox of persuasion, is the way he put it. One of the most important rules of advocacy. The more you argue, the harder you push, the more the judge and the jury resist what you have to say. That's his quote. The reason is, and I think you identified this in your discussions about opinion stories, is no one likes to be told what to think, especially Americans. People like their own ideas. And I've seen this over and over again watching mock juries that are created for research purposes. They create their own examples, they create their own analogies in deliberations, and they rarely repeat the arguments that these highly skilled advocates have given to them. They prefer their own ideas. So a recent example I'll give you is from a different case. We'll get off of the Company X case. I spent the entire month of February 2020 in a jury trial in New Mexico. We were against some of the lawyers who were involved in the case that was made into the movie Erin Brockovich. They were representing 7 plaintiffs who were claiming serious personal injuries from living near an oil production facility. And from the beginning of the case, we suggested to the jury how to think about the issues, but not what to think about them. The opposing lawyers did the opposite. They told the jury what to think, and they claimed that the evidence pointed to only one conclusion in the case. We showed the jury the investigation that we had done and the conclusions we had reached, but we urged them to do their own investigation with the evidence we were presenting in the trial and to draw their own conclusions from it. And after a month of evidence and 4.5 hours of closing argument, with the other side yelling and cajoling and lecturing to the jury most of the time about how they should decide the case, the jury deliberated remarkably for 1 hour after a full month of evidence and returned a verdict for our side. And in an interview after the trial, the jury foreman reported, particularly, the jury did not like being told what to do. They were quite irritated with the opposing side's presentation. They felt their intelligence was not respected by the opposing lawyers. And of course, we had done just the opposite. We urged them to exercise their own judgment. We told them what we had concluded based on our work, but that it was up to them to draw their own conclusions from the facts we laid out and presented to them. I would say one other thing, Alex, back on context bridging. In a lot of these cases, when we're representing energy companies, what people have in their head is what they've learned from the time they were in kindergarten. It becomes a really, really difficult challenge for lawyers representing energy companies in cases, because we have to try to undo a lifetime's worth of learning and knowledge and assumptions that some of these folks show up with in their minds.
So one thing I think maybe implicit in what you just said, but we've talked about before, where you're I think part of what you've become better and better at doing is sort of giving the perspective of how you, as the attorney, discovered the truth of the case. Can you talk about that a little bit?
Right. I try to stay away from, there's a rule prohibiting attorneys giving their own opinions. So I have to do it more in terms of what my client has done. So in the case I mentioned in New Mexico, I just started at the very beginning. I said, look, this is when this issue was first presented to us. These are the things that we did. We interviewed these people. We looked at these documents. We studied these aerial photographs. We looked at government records. And as we worked through the investigation, we realized that this is what occurred. And this is what had caused these issues. And this is what the problem was. And our conclusion based on that is that, we're not responsible for that, because what happened to these people was that a builder had decided to build a neighborhood in the middle of an oil field, and he had built some homes on top of old oil production facilities that were in an active oil field. That really wasn't our client's responsibility or problem. And we urged the jurors to sort of take their own tour down that investigation path, and conclude what they thought was appropriate. This is what we had concluded after what we had done. And it gave us a way to present all the relevant facts without sort of telling them this is the conclusion they had to reach. This is the conclusion they had to come to.
Yeah, I mean, of all the things I've figured out with intellectual persuasion, I often find that opinion stories are the most powerful. They're the ones that are easiest to learn and apply. And when I do talks about communication, or better yet, workshops about communication with organizations, one thing I really focus on is helping the people there develop their own opinion stories. And there are certain kinds of elements of an opinion story. Maybe we can link to, I don't know if I have any online presentations about this, but I mean, one of them, just one, there are a bunch, actually, no, there's a Human Flourishing Project about opinion stories. So I can link to that. But for instance, one pitfall with opinion stories is sometimes people will say in effect, when I was your age. So they'll hear somebody with a different opinion and they'll say, oh, well, I used to believe that, but in effect, now I'm not dumb. And one thing with opinion stories is you don't refer to the other person. You just tell the story of how you think, and then they can apply to themselves or not. But as soon as you say, oh yeah, I used to believe what you believed and now I don't, I mean, nobody likes hearing that. And there are a bunch of others, so I'll make sure to link in the show notes to that episode of the Human Flourishing Project. I have a couple of final thoughts on this, but Michael, before that, anything else you wanted to share about this issue of intellectual persuasion and then how it's applied to your work in energy law?
Yeah, I would like to say one last thing. In this case we just talked about in New Mexico, I had to argue for 2.5 hours, 2 hours and 15 minutes actually is what each side was given. And there was a heavy dose of your concept of opinion stories and arguing to 100. And after the trial, the judge called me up and she said to me, that was the finest closing argument I've ever heard in any case. and I was really a little bit taken aback, but I attribute much of that to these ideas. But I'll tell you one other thing as well. I didn't know this, but there were 2 other district judges who were sitting in for closing arguments as well. And they had made similar comments to one of my witnesses who lives in that community, who ran into the judges after the trial, that it was really one of the best arguments they had ever heard, a summation they had ever heard from a lawyer in a case. And so, hat tip to you, Alex, for these great ideas which I employed in this trial, and which had obviously a powerful impact on the jury because we won, but also on the judges who are sort of unbiased with respect to the issue of advocacy anyway.
Well, that's really cool to hear. I don't think I had actually heard that part of the story. I think I had heard that somebody approached you later, like a juror or something, but I didn't know that it was the judge saying that. So my final thought on this is one perspective that's helped me a lot, really, since I was 18 years old. So almost 22 years ago now, or 21 and a half years ago, is that for whatever reason, I've always had the idea that if I can't explain my point persuasively, there's something that I'm not doing right and there's something I can do better. And I think there's often the premise that, well, if I explained it and I tried my best and they didn't agree, then there's something wrong with them and I don't need to change. And my premise is, no, there must be a better way of explaining this. And I'm always on the lookout for better ways of explaining this. And any innovations I've come up with have come from that mentality, from always looking for better ways to explain things. And I would encourage anyone in any realm of persuasion, if you're in the energy context, we can think of investor relations, we can think of legal issues, we can think of government issues, we can think of environmental type issues. Don't assume that you are already using anywhere near the best possible form of explanation. I sometimes think, well, in 500 years from now, I'll bet they'll have discovered some really good forms of explanation that we're clueless about now. So maybe let me try to push it at least a little bit in that direction. And so you want to think about, just with any project you're working on, what can be done to explain this point better? Because every little bit you can get better at doing it, that can lead to dramatic results in terms of success. And sometimes I use the analogy of a combination lock, one of those 10-cylinder bike locks, and the idea is you have to open all 10 cylinders for it to work. So you might get 8 of them right, and then you pull it open and it doesn't work. But then you unlock the 9th and the 10th, and then everything opens up. And sometimes explanation is like that. Sometimes there's just a little thing missing, and then everything opens up once you fix that little thing. So I just really encourage people to assume there are much better ways of explaining things, and then to try to innovate on that, or to try to find people who can help you. And obviously we have one here. So Michael, in terms of legal work, how do people, or anything else, how do people contact you?
Well, michael.mazzone@haynesboone.com is the email address. That's the best way.
Okay. And Michael is standard spelling, and Mazzone is Mazzone. So it's Michael Mazzone or Michael.Mazzone?
Michael.Mazzone.
Michael.Mazzone@haynesboone.com. And Michael and I have done some work together. So if you're interested in using both of us, that's at least definitely an option. If you want to contact me about this or anything else, of course, it's alex@alexepstein.com. Michael, thanks so much for coming on the show and for sharing these really cool experiences.
You're welcome. Thank you for having me on.
All right. Talk to you soon.
Thank you.